Matter of Bodenmiller versus DiNapoli.
May it please the court, I'm Wayne Schaefer. I represent the petitioner in this case, Robert Bodenmiller. I would respectfully request 3 minutes rebuttal time.
Yes, sir.
The decision of the Third Department should be reversed because the standard, whether or not a precipitating event could be reasonably anticipated, is unsupported by the decisions of this court and the language of the statute, Retirement and Social Security Law, Section 363C. In making its ruling below, one of the pivotal phrases employed by the Third Department was, quote, "It is logically consistent that a condition could be readily observable, but that the precipitating event itself could still not be reasonably anticipated." This characterization overlooks and ignores the fact that what underlied the emphasis or the need to point out the immateriality of readily observable was the fact that it was brought up in the context of trying to justify a resolution of the issue of whether it was accident. We're not talking about any readily observable accident. As the dissent pointed out in Kelly, actually it was a matter of Sika.
Well, there's a little bit of confusion here. The readily observable language, the Third Department has clarified, applies to the condition, whereas the reasonably, that one can anticipate it, right, reasonably anticipated, applies to the precipitating event.
But that's exactly the point.
The holes are the condition, the wheel getting stuck in the hole and the chair tipping over is the precipitating event that results in an injury.
But that's precisely the point. Whether you call it a readily observable condition or a reasonably anticipated event, the underlying materiality is the same. It has to be something that's relevant in the context of communicating notice of a hazard. There's really no substantive distinction between the two of them. The reality is that and I think everyone can agree, the case law in this area has not been consistent or a model of clarity. The lodestar has always been whether, starting with the analysis of the facts and circumstances, whether the injury resulted from an accident inherent in that particular applicant's job duties. Once it is determined that it was not inherent, then it's found to be an accident. Now, in determining whether it was inherent in the job duties of the officer, in other words, addressing the overriding question under Lichtenstein, whether it was a sudden fortuitous event, there is case law, as highlighted by matter of Rizzo, that allows an inquiry factually as to whether that applicant knew about that hazard at that time and as a basis for finding what otherwise would appear to be fortuitous and unexpected. In fact, in that particular case was not, in that case.
To pick up on that, right? So in Rizzo, we said that because the petitioner conceded that she knew that the door would slam, the heavy door would slam, and her movements were intended to avoid the closure, that it could not be the cause of an accident, right? So her actual knowledge precluded finding it was an accident. And so it seems to me here that there is perhaps likewise an acknowledgement that the ruts are in the floor. Why is that not the same as what we found in Rizzo to preclude the finding of an accident?
Because in Rizzo, it was a finding of actual knowledge of a hazard, not of an underlying condition. In Rizzo,
Wait,
the finding was...
can't a hazard be an underlying, or the other way around, can an underlying condition be a hazard?
It has the potential to be a hazard, obviously, but the question is if you're going to take away, or if you're going to make a factual finding that a particular applicant had sufficient knowledge so that what otherwise ordinarily would be a fortuitous event is in fact no longer fortuitous, it seems to be common sense that you have to make a finding that the individual had knowledge of something,
So-
a hazard that would cause him to change his behavior.
The practical translation of that principle that you just stated would be that here, the claimant had knowledge that there was a rut in the floor, but not knowledge of the fact that the rut was so severe that it could cause a chair to tip over? Is that it?
Exactly, and we make this point emphatically on brief. We point out that all that this record established was that he had a general knowledge of the floor condition, generally, just like people who go into offices all across the country have a general knowledge of the condition of the floor where they go in, of the condition of the room where they go in. What Rizzo says is
What would
that
it have taken for this claimant to have knowledge of the hazard, short of actually having, short of what actually happened to him?
as Rizzo instructs us, it's precisely what respondents said should have happened here at some point. For example, requesting a apron underneath a chair, requesting some remedial measure, something which would have allowed a nexus
Did that
to be
happen in
drawn.
Rizzo? Did she request a remedial measure?
What she did, she testified, I believe, the evidence showed that she engaged in evasive movements, which confirmed that she was aware of the actual hazard.
Well, he did concede, I think, several points in the record, that he knew that the holes were there in the floor, and he says that he wasn't aware of the severity of them. But he is acknowledging, though, that he understands that they were there.
He acknowledged that there was a generally deteriorated condition of the floor, which included holes.
I thought
That's
it was a
correct.
little bit more. I thought he recognized that they were about 3 inches. I thought he also said that they were near the chair, or the chair was near them.
He may.
It's a little bit more than saying, I looked and I saw that, the carpet was a little bit ragged.
He may have referenced the width of the holes, but of course, it wasn't the width of the hole that caused the chair to get caught. It was the depth of it, and there's no evidence that he had any awareness of the hazard arising from.
He knew there were
the
several
depth.
holes.
Well, he knew there were holes.
He knew his
in
chair
the-
had wheels.
And
He
the
knew
pic-
the only way to use the chair is to push off from the wheels, right? You have to roll over that floor.
That's true, but the reality is, generally speaking, knowledge of a condition, as we mentioned on brief, we have all worked in offices, and we have all acknowledged that they've had less than perfect environmental conditions.
Well, but Rizzo does hold, I think, tell me if you have a different read of it, that there, the claimant's knowledge of the risk precluded finding it was an accident.
Because she had knowledge of the actual risk,
Right,
that's
okay.
true. It's an
And
individualized
so-
inquiry.
Yes, and so isn't then the question whether or not his admissions that he knew about the holes, and the holes, whatever we want to call them, ruts, are in the record, they're clearly significant, and he testifies that he knows about them. So I'm just struggling to understand how that's different from what we have in Rizzo. Maybe you can help me with that.
Well, it's different in a procedural context as well, given the fact that although the retirement system did raise the issue of direct knowledge akin to Rizzo on brief, that was not the ground that the hearing officer and ultimately the retirement system relied in denying the application. They specifically invoked the reasonably anticipated criteria used in Stanachrone. They did not find, akin to Rizzo, that there was direct knowledge. They found that, again, and this is the problem with the reasonably anticipated standard, it is not an individualized inquiry which looks to the actual state of mind of the applicant. It is not something that's premised on the things that administrative law judges are supposed to be doing in these hearings, evaluating testimony, reviewing documents, making evidentiary findings, empirical findings. Instead, reasonably anticipated is essentially a judicial construct along the lines of a finding of, the only thing you can really compare compare it to would be something like contributory negligence.
Or foreseeability. I mean, in the negligence, in a negligence case, right, I think that we do have courts all the time look at the question of whether something was foreseeable, and it seems to me that that inquiry probably is similar in a lot of respects to the question of whether something was reasonably whether a risk was reasonably anticipated. So I'm not sure why courts would be, or the hearing officer would be ill-equipped to handle that question.
But as Justice Wilson pointed out in dissent on a matter of Rizzo, reasonably anticipated is in fact either redundant or unwarranted. It's redundant because
But that's a different, if I can, that's a different question, I think, than whether the courts or the comptroller can capably answer the question, right?
even if they can capably answer that question, the question is, are they empowered to answer that question under the law? We submit the answer is no. There's no provision under the law, again, as was pointed out, for a hearing officer to entertain the question of whether, in his mind,
So you're,
beyond-
just so I understand your test, if I can call it that, if a reasonable person would have anticipated a particular danger, but the plaintiff in this case doesn't, for whatever reason, unreasonably fails to notice the danger, that's still an accident.
it's still an accident if he fails to reasonably anticipate, if he does not have actual knowledge of the hazard, there would still have to be a finding if, in fact, there was a sequence of events which were not within his inherent job duties. That's correct. I notice my time's expired.
Thank you.
Not to jump the gun, but perhaps I will. Can you address whether you think there is a meaningful distinction between readily observable and reasonably anticipated, and if so, what it is?
Yes, Your Honor. The readily observable test asked how easily the hazard could be perceived with our senses.
The hazard or the condition, are those the same thing?
Well, I think, there is an analytical distinction between the two, but I think, readily observable is important in determining whether something is expected. And that's a clarification, I think, that this court should make to the third.
No, but I don't, I'm not answering Judge Halligan's question, and it's in part what I was trying to get to with your adversary at the very beginning. Is that referring to the condition itself or the precipitating event? I mean, the condition could be the hazard, I'm not going to tell you otherwise, but perhaps something else is the hazard.
Well, I think, and let's go back to Rizzo. Rizzo says that.
Well, what does the third department say?
I'm sorry?
What does the third department say? Since it's their standard.
The third department, I believe they say that it's the hazard.
So if we start with Kelly, right, which I think is where you were about to address footnote 3, what the court says in Kelly is that the requirement that a petitioner demonstrate that a condition was not readily observable to show an accident is inconsistent with our prior case law, and cites some cases, including, some that involve the slip and falls, right? One could read that as saying that's not an affirmative obligation that a petitioner must meet, or you could read it, I suppose, as suggesting that the inquiry itself is not appropriate in determining, the court or the comptroller should not engage in that inquiry. So I guess I'm interested in your view both of what footnote 3 means, that statement, and whether or not that precludes consideration of reasonably anticipated in deciding whether something's an accident.
We think that the footnote means that petitioners aren't required to prove affirmatively that a hazard was latent or hidden. But readily observable isn't the issue in this case because the record shows that petitioner actually observed the holes. So we don't need to ask whether they were observable. But readily observable does differ from reasonably anticipated because, again, readily observable asks, what can we perceive with our senses? Reasonably anticipated, as the third department has articulated it, looks to what a person in petitioner's position and location could or should have expected.
So to go to Judge Halligan's term used before, it's akin to a foreseeability type of analysis.
That's right. It is similar to foreseeability. And this is where we get a tension in these cases because of the willful negligence clause in Section 363. The tension is that the term unexpected in the court's definition of accident suggests an ordinary negligence standard, while the statute carves out only willful negligence. But the legislature seems comfortable with that tension. It has left this court's definition and the third department's implementation of that definition in place for decades, even while amending the RSSL multiple times.
So what does that mean? Do we just ignore willful negligence because the legislature seems to have tolerated all these little chips at it?
Well, certainly, if someone is willfully negligent, then it's not an accident.
No, but what if someone's something less than willfully negligent and it's still not an accident?
Well, there's a whole body of case law where people were less than willfully negligent, and it's found not to be an accident because they could or should have reasonably anticipated the hazard.
Could you have an accident under the standard definition that we've given, then lose on willful negligence? Could something be unexpected, but you're somehow willfully negligent in becoming injured?
Certainly, I'll give you an example. Imagine two police officers roughhousing in the station house. And in the midst of that tussle, one of them slips on a pool of water. And the pool of water they didn't see, wasn't reasonably anticipated. But they were in the midst of willful negligence. They were having a tussle that they shouldn't have had at work. So that's an example that where...
A little unclear. How would they not have anticipated they might fall and slip if they're roughhousing?
They wouldn't have anticipated falling.
Why not?
They wouldn't have anticipated slipping and falling on a pool of water.
Because they didn't see the water? Is that your argument?
Because they didn't expect the water would be there and they didn't see it. They wouldn't have reasonably expected the water to be there. They wouldn't have reasonably anticipated it. And I do agree with opposing counsel that whether something's reasonably anticipated...
So if they like slipped just on the floor, not water, the foot kind of caught while they're roughhousing, is that an accident?
I'm sorry.
If there's not water that causes the slip, it's just the physicality and someone's foot, gives way.
Well, if they're roughhousing, that's willful negligence. So they don't get accidental no matter what. They're out because they fall within that carve-out.
So if we use some aspects of ordinary negligence to decide whether something is an accident, which I think is what you're suggesting, right? What do we do with the cases in which there is a finding of an accident where it looks like, you slip and fall sort of case? Are those cases correctly decided under your view?
Well, there is this tension between the court's decision in Kenny, where a person slips and falls on a wet surface, rainy day. That's not an accident.
And McCambridge.
And McCambridge, Knight, which was one of the cases decided in McCambridge. And I think that there's this line of cases, Knight going all the way back, I think, to the late 1980s, and since then there's been this line of cases, Lang, where the person tripped over the computer wires that she could obviously see. Kenny, where the person slips on wet surface, almost the same facts as Knight. And finally, Rizzo, where the person reasonably, I'm sorry, not reasonably anticipated, but where the closing door was a known condition. And I want to underscore known condition in contrast to opposing counsel. In Rizzo, the court held that a known condition, not a known hazard, but a known condition cannot be the cause of an accident. That's 39 New York 3rd at 992. And in Kenny, the court explained that when you know about a hazard, it's not unexpected.
But in some of the slip and fall cases, is it your view that they came out the way they did where it is found to be an accident because there's some implication that the claimant didn't see the water? I mean, do you think there's a way to harmonize all of those cases or not?
I mean, we tried.
And how is that?
We tried to do so in our brief. If you can't see the water, cannot see the water, and there's no reason for you to be looking down to see the water, and you don't reasonably anticipate water, then it's an accident. But if you do reasonably anticipate water, for instance, on a rainy day, then it's not an accident, it's reasonably anticipated. And here, again, remembering that this is a substantial evidence case, there is substantial evidence that petitioner not only reasonably anticipated the condition, but actually knew of it, just like in Rizzo. Page 110 of the record, question, were you aware that there were ruts in the floor prior to sitting down that day? Answer, I was aware of the condition of the floor. Page 104, question, but you had seen the condition of the floor prior to getting stuck. Answer, yes, I glanced at the floor. I saw it, yes. Now, petitioner's claim that he didn't appreciate the severity of the holes doesn't transform the event into an accident. There is no accident when an injury is caused by a known condition that gives rise to a reasonably anticipated risk.
Is that the difference between a subjective and an objective opinion?
I think so. Certainly, this petitioner subjectively knew that there were holes in the floor, and in fact, he knew the holes were in the exact spot where the chair wheels would be. The exact spot, that's page 107 in the record.
But I think his point is that while knowing that the holes were there, that he didn't anticipate that the chair would tip over. So what do you do about that piece of it?
Well, for a risk to be reasonably anticipated, and again, going back to the question before, that's an objective standard, and we argue that in the brief. You might not subjectively expect it, but if everyone else, if a reasonable person in your position and location could or should have expected it, then not an accident.
So why, in this case, would a reasonable person have expected it?
Because
The center didn't think so maybe they're reasonable, maybe they're not. But in response to your adversary.
there are holes in the floor. He sees the holes in the floor. He notes that the holes in the floor are at least 3 inches across. And he notes that the holes in the floor are in the exact spot where his chair wheels are going to be. And a reasonable person in that position with that knowledge would anticipate that the chair wheel is going to get caught in a hole, and
So
there might be a problem.
there's a thunderstorm, the roof on the firehouse is leaking, a firefighter goes up on a ladder to try and patch it so the water doesn't pour in, and is hit by lightning. Now, we understand that a thunderstorm, brings lightning with it. Accident, not an accident.
I would say not an accident, because I was always taught as a child not to go out in the thunderstorm because you could get hit by lightning. And I think most people know that. A reasonable person in that position and location would know that. Don't go out on the roof of your building because you could act as a lightning rod. And that would not be.
Regardless of the risk. Let's say the odds were 1 in a million.
We wouldn't say that was a sudden fortuitous mischance.
If you put yourself in harm's way, that's not a sudden fortuitous
Well, but that's what
mischief.
first responders do as part of their jobs. They put themselves in harm's way all the time.
Well, exactly, and
So they're disabled from getting, I didn't mean to use it that way, ADR benefits?
well, yes, because that's an inherent risk. These people are paid to encounter risks. So you don't get, if you're a first responder, you don't get accidental disability retirement every time you're injured. And the reason for that is you're paid to go out, you're paid to encounter risks. It's an inherent risk of your job. And I think the next case on the calendar is going to examine that inherent risk doctrine. Yes, an inherent risk. Now, getting struck by lightning, not an inherent risk of being a fireman, a firefighter, so then you go to the next level of, well, would a reasonable person in that position and location have expected to get hit by lightning? And you could reasonably expect to get hit by lightning if you're on top of a roof in a thunderstorm.
So does the controller embrace this third department two categories approach?
Yes, the controller tries to follow the third department, and did so here. I would differ with
Well, I know you try to
opposing
follow, I
counsel.
understand that, but do you think that is an appropriate way to address these kinds of cases? Right, these
Yes.
two
yes,
categories.
It is.
And an administrable way, right? I'm asking you a question.
Yes, yes. What we need clarification on is what does the fact that something is readily observable do? Because there have been arguments since footnote 3 in Kelly that you can't use readily observable at all.
Well, are you distinguishing that from reasonably anticipated, or are you treating them as one and the same?
I'm treating, I think readily observable is a fact that bears on whether something is reasonably anticipated. So it would be wrong.
But they're not synonyms, I take it you're saying.
They're not synonyms, no.
No,
Because
but
again,
that's again begging the question, what is it one is observing versus what is it one is anticipating? I thought that the third department was saying these phrases apply to two different things.
I
One can
agree.
observe the condition, right, versus anticipating the precipitating event.
I agree with what Your Honor just said. And here, Mr. Bodenmiller observed the holes, and he could or should have reasonably anticipated the event. But in any event,
So in this case, the fact that he observed, let's just assume that for one moment. I know you take issue with that. Let's just assume it for one moment. The fact that he observed the ruts, the holes, leads to this conclusion that it's reasonably anticipated that the chair with the wheels might get caught and it'll tip and you'll get injured.
given all the knowledge that he had, that's correct.
And if he had never seen the holes,
If he hadn't seen the holes,
actually, as a matter of fact, had not
right,
seen
if
the
he-
holes.
If he hadn't seen the holes,
Yeah.
I think that would make this case turn differently. This case would be
So if there was a
like-
carpet, for example, on the floor, and so he couldn't see the
Right,
holes,
if he-
in
if he
fact,
couldn't-
and had
if-
no experience having, run into them.
Right, if he couldn't and didn't see the holes, I think this case would be like Pratt, where the firefighter dismounts from the fire truck and steps in a pothole. And he didn't see the pothole, he didn't have any reason to look for the pothole. Court holds it's an accident. That's this court. So I think the case would...
Except there are potholes on the street, so it's a little bit odd with that case. But here, one need not, right? It's not sort of an automatic thing that one assumes there are holes in a floor. I think this is
agree.
kind of the
One
stronger
wouldn't
case.
automatically assume holes in the floor. And what the basis of our case here is the fact that he actually did see them. And that's, I think, what substantial evidence bears out.
Thank you.
Thank you.
Very briefly, again, as someone pointed out, applying a reasonably anticipated standard here, in fact, begs the question This question is whether it can be supported as a matter of the applicable statutory law in the decisions of this court.
Yes, except that in Liechtenstein, one of the words used to explain an accident is unexpected. So,
That's correct. And
It's
now-
anticipated, it is the opposite of unexpected, it is expected.
But remember, we only get to the question of reasonably anticipated
Yes.
once we have already determined that the actual accident was unexpected, because there's already been a determination that the accident was not a consequence of duties performed in the normal course of employment. Even the third department agrees to that. The third department in this
You mean
case...
you only get to that if you've made a decision about whether or
Right.
not it's a risk inherent to the job?
The third department in this case specifically found that the incident where he tipped over in the chair was not a risk inherent in his police
But
employment.
that's different than it being an accident. So, as I understand it, you know, a firefighter can rush into a building and get hit by debris. It's an accident, but it's inherent risk in what that firefighter's duties are to go into a building, to try to save someone. So then, if it isn't that, if it isn't an inherent risk, then you get to accident. Is this an accident? Because that can be an accident and you're still not going to recover. It's not intentional, right? Somebody runs in a building, thing falls down, you don't recover, that's a line of duty recovery. So I disagree with kind of how you're splitting it. Then you get to accident, and then you have to show it's unexpected or whatever our definition is. No?
We have tried to follow the guidance of the cases here, and it seems to us, basically, that there's been a clear, bright-line demarcation. First, you address the issue of whether there's a, quote, accident within the meaning of Liechtenstein, something that does not occur in the, as a result of an inherent risk, and then you get to these peripheral issues, for better or for worse. And that is part of the problem here.
Well,
If we go to a... I'm
Isn't
sorry.
your position that if it's not inherent in the work, then it's automatically an accident? Or is there has to be a determination? I think you're saying it is automatically, and I don't think that's what our case law says.
It's sort of bringing it in through the side door, if I may. I'm not putting it strictly in terms of saying that Rizzo is a, quote, exception to something that would otherwise be an accident because it was not inherent in the job duties. I'm saying that Rizzo countenances a finding that if, as a factual matter, in a given case, it's determined that an applicant had actual knowledge of a hazard that would cause a reasonable person to forego certain behavior, that in that case, we're going to say that it was not something that did not occur as a result of something not an inherent risk of employment.
This is how the appellate division described this. The first category involves precipitating events that arise out of a risk inherent in the petitioner's ordinary job duties, the work performed. Precipitating events that fall within this category can never be considered accidents because by definition they are not unexpected and therefore cannot be the basis for accidental disability. The second category are precipitating events, not accidents, precipitating events that do not arise out of these inherent risks. Precipitating events that fall into this category may be deemed accidents, but only if they are unexpected, out of the ordinary, and injurious on impact. So that seems pretty clear to me. Precipitating event, inherent risk, not inherent risk, is that precipitating event an accident?
I see your point, but again, to try to distill this into a comprehensible framework, I don't see how you get to a point where you can not make one determination initially, followed by the second determination. In other words, it's true that something that occurs as a result of an
But
inherent
I'll give you an
risk.
example. Beam falls on a firefighter's head. If he's in a building, that can never be an accident, that he's rushed into and there's a fire. If he's in the office, then it can be an accident. That's, to me, is the difference, right?
If and again, I don't really mean to belabor, the wordplay, for lack of a better word of this, but in the second example, if he's in an office doing paperwork, and he is not assigned to a position where he ordinarily does paperwork to foreclose that argument, that he's, an administrative lieutenant or something. Let's just say he's a police officer, he's a firefighter who has to make a loan report, something outside of the ordinary course of his duties. And he's in that room, and a beam falls from the ceiling, and it hits him.
But that's not an inherent risk of his duties. of
That's the
going
whole
to
point.
office.
It's
Right,
an
so
accident.
you get to step two, but then you have to say, okay, was it unexpected? Is it an accident? It's a precipitating event, it's the same precipitating event type, but in the first case, you never get to the second part because it's inherent. In the second, you do.
That's the point. So what do you do once you get to that point, okay? Do you conduct an administrative hearing to determine as a factual matter what he knew when he knew it? Or do you allow a hearing officer to substitute his beliefs as to what that officer should or shouldn't have known at that given time,
Or do you
usually a
let
year
the
and a half after the
officer-
fact?
Or do you let the officer look at the entire record, make a determination as to whether it was unexpected, and then review it under our standard?
Whether it was, we've already established that as a matter of the case law typically, it was unexpected. It was not, it was a fortuitous event within the meaning of Liechtenstein. If you're going to go beyond that, it seems to us.
But that's not the holding of the appellate division here, right? They didn't say that it was an unexpected event, but somehow reasonably anticipated. The point of this decision, as I read it, is that whether something is reasonably anticipated or not goes to the very crux of the determination about whether something is unexpected.
Then why did they go to the trouble of characterizing what happened as something that would meet the qualification of accident under Liechtenstein in the first instance, which they said. They made that ruling. Why do that if you're going to somehow preserve, the question when you've already moved beyond this issue to go to the issue of whether something, even though it is otherwise accidental within the meaning of Liechtenstein, the benefit should be denied because in hindsight, it should have been reasonably anticipated. We just don't think there's any basis in the law for this. The reality is the law already provides a standard of sorts to disqualify people from receiving a benefit that otherwise would qualify as something that was accidental. That's the willful negligence standard. To the extent that that standard should be changed, I think this is an appropriate question for the legislature.
Thank you, counsel.
Thank you very much.